Good afternoon, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 19th lecture series. So far, we have delivered 18 lectures. Every videos are available on YouTube. Therefore, you have not missed anything. You can watch those videos and you can make notes. Yes, link will be provided, sir. Now, today's lecture is on the topic scope of special leave petition. This is very important topic because special leave petitions, majority of the cases filed under Article 136 of the Constitution of India. So before going to the topic, it is our routine practice that we recite the preamble of the Constitution as our prayer. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, this is always remained as our earnest request to all our members that not only reciting this preamble, each words we should understand the core meaning, and we see to that it becomes part of our life as well as for the remaining other fellow citizens also. So this is the ultimately the goal of the entire Constitution, to achieve these goals embedded in the preamble. Now moving on to the topic. So far we have discussed about special leave petition and introductory. Thereafter, when the Honorable Supreme Court will interfere under Article 136, we have seen nearly 5 illustrations. Before going to these 5 illustrations, let me narrate what is Article 136 is. Article 136 of the Constitution of India begins like this. It has 2 clauses, Clause 1 and Clause 2. Clause 1 says, notwithstanding anything contained in this chapter, the Supreme Court may, in its discretion, it is may, it is not shall. So therefore, it is a discretion vested with the Honorable Supreme Court. So the Supreme Court may, in its discretion, grant leave to appeal against judgment, decree, sentence, order, or determination. So they have not used only the judgment alone. It is an order, maybe a final order, maybe an interim order, passed by any court or tribunal. It is not only the High Court, passed by any court or tribunal in any cause or matter pending in the High Court within India. So this is what the Clause 1 says. So it's an appeal to the Supreme Court against any judgment, decree, determination, sentence, or order passed in any matter, passed by any court also, passed by any court or tribunal in any matter. That is, comes to the Supreme Court. The second provision is, that is an exceptional provision to Clause 1. They say that judgment, an appeal, when an order is passed by any court or tribunal with respect to the law of armed forces, then such an order will not be appealable to Supreme Court. So firstly they say any order can be appealed to the Supreme Court, but any order passed with reference to the armed forces, that is not appealable to the Supreme Court. So clause 1 is the general provision, Clause 2 is the exceptional provisions. Hope it's clear, dear friends. Thereafter, we have seen what is the wide discretionary power granted to the Honorable Supreme Court. Because it says that any order passed by any court, they can come to the Supreme Court. So why such a wide discretionary power vested with the Honorable Supreme Court? The reason is to change the injustice. The power is limitless. There is no limit at all to the Honorable Supreme Court power to interfere and set aside the impugned orders when there is an injustice caused to the litigant. So such a wide power is vested with the Honorable Supreme Court. Therefore, it will be exercised by the Honorable Supreme Court very cautiously, sparingly. So it cannot be applied just in all the matters. So it has to be applied only in exceptional circumstances. So for which we have taken nearly 5 illustrations. The first illustration was non-speaking order. An order passed without any reasons. So absence of speaking order, number 1. Number 2, when the Honorable Supreme Court can interfere with the concurrent findings passed by the courts below. That was the second illustration. Third illustration, when the Honorable Supreme Court can interfere with the sentence or the fine imposed by the courts below. So when the sentence or fine, it is a discretionary power vested with the Honorable High Court or the courts below to impose sentence or fine. Even in their discretionary power, when the Honorable Supreme Court can interfere. That is the third heading. Fourth heading is when the Honorable Supreme Court can interfere with the interlocutory orders. So when there is an interim order passed, when the Supreme Court can interfere. Last but not the least, the fifth point is when the Honorable Supreme Court can interfere with the mixed question of facts and law. Generally, we have heard that on substantial question of law, the Honorable Supreme Court will interfere. But when the Supreme Court will interfere, when there is a mixed question of facts and law. Hope it's clear. These are the 5 headings that we gave and we discussed last time. Now we need to cover only the last two topics. That is, when the Honorable Supreme Court will interfere with the interlocutory orders, and then on the mixed question of facts and law. So for this, now I am coming to the interlocutory orders. To understand what is the interlocutory order, we must see the definition clause that is there in CPC section 2 clause 14, section 2 subsection 14 of Civil Procedure Code defines what is order. Dear friends, from the senior advocates, from the judges, we understand that when you are reading one particular provision, maybe CPC or CRPC, whatever, you cannot read it in isolation. You have to read it along with the other provisions. For example, we are reading Article 136, but we can take reference from Civil Procedure Code also to understand what is the meaning of order, as well as from the Supreme Court rules also. What is the definition given in the Supreme Court rules? So if you look at section 2 subsection 14 of Civil Procedure Code, which gives the definitions of order. Order means the formal expression of any decision of a civil court which is not a degree. I repeat, order means the formal expression of any decision of a civil court which is not a degree. Now, let me take you to Supreme Court Rules 2013, Rule 2K, which defines judgment. Rule 2K of Supreme Court Rules 2013, which defines judgment. Judgment includes, they are not giving any definition of judgment. Judgment includes decree, order, sentence, or determination of any court or tribunal, judges or judicial officer. So this is what the definition of judgment given in the Supreme Court rules. Now, having understood this order, so now let us move on to what is interlocutory order and when a Supreme Court can interfere with the interlocutory orders. Generally, the practice of the Honorable Supreme Court will not interfere with the interlocutory orders. Interlocutory orders, ad interim order or interim order. So generally the Supreme Court will not interfere. But under what circumstances they will interfere? First, let us ask this question, why they do not interfere. Reason is, when Article 136 itself, that they will exercise very cautiously. Interim orders means, that means main suit or main case is pending. It is only as an interim relief that was granted. So by looking into prima facie case, irreparable loss or balance of convenience, so the discretionary power being exercised by the courts below while granting the interim relief. So therefore the Honorable Supreme Court restrains itself. There is no absolute bar, but they have imposed restrictions on themselves not to interfere with the interlocutory orders. But under what circumstances they will interfere? So for which I have 4 cases, dear friends. The first case is Gangubai, Bobliya Chowdhury. Gangubai, Bobliya Chowdhury versus Sitaram Balchandra Shuktankar. I repeat, Gangubai, Bobliya, Bablya Chowdhury versus Sitaram Balchandra Shuktankar. It is reported in 1983, volume 4, Supreme Court Cases, page number 31. This is a judgment delivered by combination of 2 honorable judges, Honorable Justice D.A. Desai and Honorable Justice O. Chinnappa Reddy. D.A. Desai. So, let me tell you what is the facts, and then I will take you to the relevant portions. Please kindly pay attention, dear friends. I will give you the brief facts of the case. Here, the plaintiff files a suit before the Honorable High Court. This for what? The suit for injunction restraining the defendants from interfering with the possession of the plaintiff. Interim injunction was granted in favor of the plaintiff, meaning thereby until the disposal of the suit, the defendants were restrained from interfering with the possession of the plaintiff. Single judge has given this order. Thereafter, the defendants, they moved an application for vacating the stay because they are aggrieved. So they moved an application for vacating the stay. The learned single judge of the Honorable High Court vacated the stay. Now plaintiff is aggrieved because the stay operating in their favor got vacated. So plaintiff preferred an appeal before the division bench. The division bench dismissed the plaintiff's appeal. Now again he is aggrieved. He approaches the Honorable Supreme Court by way of special leave petition. So in the special leave petition, the Honorable Supreme Court has held, generally we do not interfere with the High Court order, more particularly in the interlocutory orders. But in this case, if you look at the prima facie case, if you look at the irreparable loss or the balance of convenience, it is completely in the favor of the plaintiff and not in favor of the defendants. So therefore, the Honorable Supreme Court has granted interim injunction restraining the defendants from interfering with the possession, meaning thereby they have set aside the orders passed by the division bench. So this is what the facts, dear friends. Now let me take you to the relevant portion. Appellants were filed a suit for injunction, that is Gangubai has filed a suit for injunction restraining defendant number 1 and 2 from interfering with the possession. A notice of motion was taken out for interim injunction, which was granted by the learned single judge of the High Court with the reservation for reconsideration of the orders on the happening of certain events set out in the order. It appears that respondent moved the High Court for vacating the order and the interim injunction was vacated. So here single judge granted injunction. Now the respondents have moved an application to vacate. Now it is vacated, it got vacated also. So after an unsuccessful appeal to the division bench, this appeal by way of a SLP. Now the most important aspect is para number 6. This is very important, dear friends, because the test is what is to be examined while granting interim injunction. When the Honorable Supreme Court or when we are seeking for an interim injunction as an advocate, how do you establish to seek interim injunction from the court? Para number 6 of the judgment I am reading. When an interim injunction is sought, the court may have to examine whether the party seeking the assistance of the court was at any time in lawful possession of the property, and if it is so established, one would prima facie ask the other side. So now the plaintiff has to establish his case that whether this plaintiff was in the possession of the property at any point of time, that he need to establish his prima facie case. Yes, I was possessing this property for so many years. When he is in a position to establish before the Honorable High Court, then the Honorable High Court will turn on to the other side, that is the defendants, and this will ask this question, ask the other side contesting the suit to show how the plaintiffs were dispossessed. They will ask the defendant how the plaintiff were dispossessed. So it is a burden on the part of the defendant to show that how they were dispossessed. So we pinpointed this question and heard the submission. We refrain from discussing the evidence and recording our conclusions because evidence is still to be led and the contentions and disputes have to be examined in depth, and any expression of opinion by this court may prejudice one or the other party in having a fair trial and uninhibited decision. So what the Honorable Supreme Court has held is, we will not discuss on the merits. Reason is the suit is pending before the Honorable High Court. So whatever, when we are going to discuss in detail, definitely that will be causing prejudice to the parties. So therefore we will not go into detail at all. Having given the matter our anxious consideration, we are satisfied that this is not a case in which interim injunction could be refused. Similarly, we are of the opinion that if respondents are allowed to put up construction by the use of the FSI for the whole of the land, including the land involved in dispute, the situation may become irreversible by the time the dispute is decided and would preclude fair and just decision of the matter. If on the contrary, injunction is granted, as prayed for, the respondents are not likely to be inconvenienced because they are in possession of about 9,000 square meters of land on which they can put up constructions. So here they have applied triple test, dear friends. One is prima facie case, where the plaintiff has established that he was in possession of the property, and second is with respect to the irreparable loss. If the defendants were allowed to put up constructions on the land, then definitely it will be a irreparable loss to the plaintiff. And balance of convenience, there will not be any prejudice to the defendants if interim order is given. So therefore, applying these three tests, prima facie, irreparable loss and balance of convenience, they have granted interim order in favor of the plaintiff. So we accordingly allow both the appeals, set aside the decision of the learned single judge, vacating the injunction in both the matters, as well as the decision of the appellate bench. In view of the fact that we grant interim relief, we direct that hearing of the suit and the writ petition from which these appeals arise be expedited. We hope and trust, dear friends, they have used the term, the Honorable Supreme Court has used the term, we hope and trust that the High Court would give top priority to the same, consistent with its calendar, because Honorable Supreme Court is the constitutional court. Similarly, the High Court is also the constitutional court. So generally the Honorable Supreme Court will not direct the another constitutional court by giving time stipulations you have to complete within 3 months or 4 months. It is always a request, or the term that they have used is, we hope and trust that the High Court would give top priority to decide this case. So from this, what we have understood is, though generally the Supreme Court will not interfere with the interlocutory orders, but in this case, considering the prima facie case, irreparable loss and balance of convenience, the Honorable Supreme Court held that interim order should be granted in favor of the plaintiff. Now moving on to the next judgment, dear friends. This is one of the most important judgments. Union of India and another versus Sudesi Cotton Mills Company Limited and another. I repeat, Union of India and another versus Sudesi Cotton Mills Company Limited. This is a judgment reported in 1978, volume 4, Supreme Court cases, page number 295. So 1978, volume 4, Supreme Court cases, page number 295. So this case was decided by 3 judges, full bench. Honorable Justice V.R. Krishnaiyer, Honorable Justice D.A. Desai, and Honorable Justice A.P. Sen. So what is the case is about? Let me give you the brief facts and then I will take you to the relevant portions. In this case, the Company Law Board has passed an interim order giving power to the central government to appoint 7 additional directors in the company. Reason is, they felt that already existing directors were acting against the interest of the company. Therefore, we need to have 7 more additional directors in the company. So that was the interim order passed by the Company Law Board. Agreed by the same, they preferred appeal before the High Court. The Honorable High Court has passed only few lines in the order. It was not a speaking order at all. They set aside the order, interim order passed by the Company Law Board. Now appeal comes before the Honorable Supreme Court. The Honorable Supreme Court considered the entire facts and they have culled out their important principles of law in one paragraph. We have taken almost 3 sessions on SLP, but honorable judges have given in 3 sentences about the entire scope of SLP. And then the Honorable Supreme Court has held that generally we do not interfere with the interlocutory orders, but if the interlocutory orders are not a speaking order, or it does not justified with reasons, then justice demands and public interest dictates us to interfere. See the beautiful terms that are being used. Public interest dictates to interfere. Otherwise, we will not interfere. So, in this case, they have said that being an interim order passed by the company law board, which is a specialized body, which felt that additional directors ought to be appointed. So, therefore, we must give respect to the interim order passed by a specialized body. And we are not dealing it in detail because already the matters are pending. But the Honorable High Court, which set aside the interim order, that is wrong because it was not supported with any reasons why they are interfering. Nothing was there. So, therefore, we set aside the order. So, if we read out the relevant paragraphs, you will understand. Yes. So, directors will remain there. Order, just 2-page order gives the entire scope of SLP. Leave granted, because under Article 136, we always seek leave to appeal against the impugned order. So, whenever they pass an order, the Honorable Supreme Court starts with the first opening words or leave granted. Para number 2 is very, very important. Ad interim order of stay passed by the High Court of Delhi has been challenged before us in this appeal. We should have hesitated to interfere with an interlocutory order following the usual practice in this court. See, this is what the general practice, dear friends. We should have hesitated to interfere with an interlocutory order following the usual practice in this court. But, exception, but where repercussions are incalculable, that means bad results are not able to estimate at all, or incalculable, and the basis of the direction, though interlocutory order is obscure, that means not clear, the ends of justice dominate. This is very, very important. The ends of justice dominate, and we may interfere if public interest so dictates. So, if the impugned order passed by the High Court, if it is obscure, if it is not clear, if it is a non-speaking order, not supported with any reasons, and the consequence of the order is damage, it causes a damage, and that cannot be estimated in terms of monetary terms, it is incalculable. So, therefore, the ends of justice dominate, and we may interfere, that is, Honorable Supreme Court will interfere if public interest so dictates. So, this is what the principle is. Now, Company Law Board has appointed the 7 directors. This order was inducted, which inducted 7 additional directors, was based on the ground that the affairs of the company in question are being conducted in a manner which is prejudicial to the interest of the company and to public interest. Therefore, 7 directors were appointed. The High Court, after hearing counsel on both sides, passed a laconic order. We saw the meaning, what is the laconic order, which says using only a few words to say something. That means absence of, it's not a speaking order. So, laconic order. So, High Court order is reproduced, dear friends. We consider, this is the High Court order I am reading. We consider that the proper order to be made in view of the circumstances of the case is to stay the operation of the order of the Company Law Board dated December 17, 1977, except as regards to Shri P.K. Choksi, Shri S.K. Mitra and P.A.S. Rao, and also to direct that the said 3 gentlemen will not vote at the meetings of the Board of Directors till disposal of the writ petition. We said there are 7 directors were appointed. So, out of 7 directors, They have granted stay. Honorable High Court granted stay for 4 people only, not to appoint them as additional directors. What about the remaining 3? Remaining 3, they were allowed to continue as additional directors, but what is the restriction? They cannot give a vote. Voting right is not there. Yes, yes. So therefore, dear friends, this is what in few lines the order was stayed. Company Law Board order was stayed by the High Court. Now the honorable judges discussing on the correctness of the High Court order. What do they say? A company of considerable financial dimensions and involved in operations using public resources as investment naturally becomes the concern not merely of the company law board but also of the economic process of the country. See, though this is a problem of the company, how judges view it, that this is not only the problem of the company but also of the economic process of the country. That is how you have to see. We always generally say that you have to see world behind the word. So in the same manner, they are not only seeing the dispute between the company and the directors, but how the repercussions, consequences that will affect the economic process of the country. The specialized body, that is company law board, with responsibility to watchdog corporate process is the company law board. When it investigates, when company law board investigates and reaches a definite conclusions and makes a consequential direction, it is entitled to prima facie respect unless there are glaring circumstances to the contrary. So when a company law board is a specialized body and it is a watchdog of the corporate process, when they come to the prima facie conclusion that 7 additional directors to be appointed, that order must be respected. We do not wish to make any observations on the merits of the matter since the High Court is seized of the case. It may well be that the order of the board may be vitiated by infirmities, legal or other. So when we want to attack the company law board order, we must establish that there are infirmities. Infirmities means serious error on the part of the company law board. When errors are pointed out, then definitely they can interfere. There is no difficulty. So it may well be that the order of the board may be vitiated by infirmities, legal or other. It may also be that the reasoning of the board and the factual foundation for it is sound. In such situations, acting at an interlocutory stage, the benefit of reasonable doubt belongs to the specialized body, that is company law board. Of course, as stated earlier, if there are good grounds to shoot down the order, if there are good grounds to shoot down the order, certainly the High Court has jurisdiction to stay its operation. If there are infirmities pointed out by the appellants before the Honorable High Court, that there is a legal infirmity or the factual infirmity, definitely the Honorable High Court can shoot down the order passed by the company law board. So, of course, as stated earlier, if there are good grounds to shoot down the order, certainly the High Court has jurisdiction to stay its operation. However, we find nothing stated in the order itself indicating why the High Court prima facie thought it necessary substantially to stay the operation of the company law board order of induction of 7 persons as directors. So from reading of the impugned order passed by the High Court, we could not find out any reasons why the Honorable Supreme Court has interfered and stayed the company law board. Nor we have any light regarding the total eclipse of 4 directors and the partial eclipse of the other 3. Why they have not stayed, why they have stayed for 4 people, why they have allowed 3 people to continue, and why they were not given right to vote. Everything is not given with proper reasons. So it's a total eclipse and partial eclipse. Unfortunately, the inscrutable face of a sphinx does not go well with the judicial process. We saw the meaning of each word, dear friends, here. Unfortunately, the inscrutable face. What is inscrutable? Not showing any emotions. Therefore, very difficult to understand, to know. Inscrutable face of a sphinx. Sphinx means it, just a minute. Sphinx means an ancient Egyptian stone statue of a creature with a human head and the body of a lion lying down. So, human face, body of the lion, and it is a statue, therefore, it has no emotions at all. If you say respect, I say I welcome you, it will not say anything. I don't welcome you, it doesn't say anything. No reaction, no emotions, nothing. So, likewise, unfortunately, the inscrutable face of a sphinx does not go well with the judicial process, meaning thereby every judicial order must appreciate all the facts, grievances, and it should be emotional also, as well as it should understand all the problems, and it must give reasons for its order. That is most important. When there is no order, when there is an order with no reasons, then it becomes a emotionless. Inscrutable face of a sphinx does not go well with the judicial process. Whatever might have been the basis of the High Court's order, we do not make any comments thereon. We are inclined to nullify the interim stay. Our inclination is explained by the prefatory observations we have earlier made in this order. To expatiate more may prejudice one side or the other. To indicate this much is obligatory to explicate ourselves. So ultimately, the Honorable Supreme Court has set aside the order of the High Court, and whatever the Company Law Board order was passed, that was upheld. So all that we need to do, and we can do in the present appeal, is to allow it so that the Company Law Board's direction in regard to 7 additional directors will come into force, full force, until the final decision of the High Court. We allow the appeal. So here in this 3-page judgment, dear friends, they have explained the entire scope of SLP. Generally, we will not interfere with the interlocutory orders, but when the interim orders passed without any reasons, if it is obscure, if there is no clarification, no clarity, then public interest dictates us to interfere. Therefore, we have interfered. So, generally, when interim orders are passed by the specialized body like Company Law Board, that is to be respected, unless and until there are legal infirmities are shown before the court. Hope this is clear. Now, moving on to this is quite interesting, 1-page judgment. Quite interesting judgment. Third judgment I am referring, dear friends. Maharashtra State Electricity Board and others. Maharashtra State Electricity Board and others versus Vaman, V-A-M-A-N, Vaman and another. Maharashtra State Electricity Board and others versus Vaman and another. This judgment was reported in 1999, Volume 3, Supreme Court Cases, page number 132. I repeat, 1999, Volume 3, Supreme Court Cases, page number 132. The facts are quite interesting, dear friends. Here, Vaman, a petitioner, has filed a writ petition before the Honorable High Court. What was his prayer? The prayer in the writ petition is, please allow me to participate in the interview for the appointment of executive engineer in the electricity board. This was his prayer. The Honorable Supreme Court has granted interim relief by saying, appoint the petitioner, giving a provisional appointment for the post of executive engineer. So his prayer was only to attend the interview. But what is the relief that was granted? Appoint him, temporarily appoint him. Enlarged heart. So that an appeal was preferred before the Honorable Supreme Court. The Honorable Supreme Court has held, even if you allow the entire writ petition, the result will not be appointment. At least you will allow him to participate in the selection. Thereafter, based on his performance in the interview, appointment will be given. Here it cannot be given at all. So therefore, they have interfered with the interim order. Hope all the judges grant this sort of relief. Advocate who appears for the petitioner as well as the petitioner will be happy. Yes. So order, leave granted. This appeal has been filed against the interim order passed by the High Court. The High Court was concerned with the writ petition filed by the respondent, that is Vaman, in which the prayer was, dear friends, this is the prayer in his writ petition, that he should be called for an interview for appointment to the post of executive engineer. So he should be called for an interview for appointment to the post of executive engineer. The post of executive engineer was required to be filled by direct recruitment. Admittedly, the petitioner had not been called for interview. Notwithstanding this, an interim order was passed by the High Court to the following effect. I am going to read the interim order. To do justice to the petitioner, we direct the respondents to provisionally appoint the petitioner as executive engineer, which shall be subject to the result of this writ petition. Notice is made absolute in above terms. There shall be no order as to cost. Within 4 lines, entire relief was granted, more than what he sought. We are conscious of the fact, this is para number 3, discussion by the Honorable Supreme Court. We are conscious of the fact that normally this court would not interfere with the interlocutory orders passed by the High Court. See, generally, dear friends, we have seen all the 3 judgments, they start, the Honorable Supreme Court starting with the opening lines that we will generally not interfere with the interlocutory orders passed by the High Court. The order in question, in this case, the order in question, to say the least, is opposed to all well recognized principles of service law, where by way of an ad interim order, the writ petition filed by the respondent has in fact been allowed, and he has been directed to be appointed as an executive engineer in the direct recruitment quota without his undergoing any process of selection. So we are doubtful, that means the Honorable Supreme Court is doubtful whether such a relief could be possible even if the writ petition of the respondent was allowed, namely he being directed to be appointed without being interviewed or any process of selection being undergone. The order of the High Court was clearly uncalled for. We therefore allow the appeal, set aside the order of the High Court which required the appellants herein to provisionally appoint the respondent as an executive engineer. So there will be no order as to cost. So in this case also, dear friends, though the Honorable High Court has given the relief what he was not sought, but though they may have the enlarged heart, but they must follow the well recognized principles of service law. So every order, every judgment must be supported with reasons. Even a losing litigant will be well satisfied with the judgment once all his contentions are recorded and fair hearing is given. Therefore, speaking order is most important. If there is absence of speaking order, the Honorable Supreme Court is bound to interfere because the public interest dictates the Honorable Supreme Court to interfere. So these are the 3 cases where I have taken for where the Honorable Supreme Court can interfere with the interlocutory orders. Now moving on to the next topic, when the Honorable Supreme Court will interfere with the mixed questions of fact and law. Generally, the Honorable Supreme Court will not interfere with the questions of fact, but here it is a mixed question of facts and law. So what is the situation? What is the position? Whether the Honorable Supreme Court, because we all know the Honorable Supreme Court will interfere with the substantial questions of law, and we also know that they will not interfere with the facts. But what about the mixed question of facts and law? Whether they will interfere? The answer is yes. The Honorable Supreme Court will interfere. Generally, this is not an exceptional case. Generally, they will interfere when there is a mixed question of fact and law. So for this, I have taken one judgment, dear friends. The name of the case is Lloyds Bank Limited. Lloyds Bank Limited, New Delhi versus Panna Lal Gupta. Panna, Panna Lal, Lal Gupta and others. Lloyds Bank Limited, New Delhi versus Panna Lal Gupta and others. This case was reported in AOR 1967, Supreme Court 428, page number 428. I repeat, AOR 1967, Supreme Court, page number 428. This is also quite interesting case. In this case, the dispute is, the mixed question of fact and law is whether a people working in Lloyd Bank Limited, whether are they workmen or the supervisors. That was the question. Why this question arose? Because if the employees bring within the definition of the supervisor, they will get rupees 50 as a concession for every month. If they are considered as a workman, they will not get it. If they are considered as supervisor, they will get it rupees 50 per month. So they approached the tribunal, industrial tribunal. The industrial tribunal held that these people are the supervisors. They are the supervisors and not the workmen, meaning thereby they are entitled to get 50 rupees per month. The appeal went to the Supreme Court. In the Honorable Supreme Court, they have discussed, before coming to the conclusion, they have discussed what are the precedent cases. They have taken one case with respect to the checking inspector. Whether checking inspector is a supervisor or a workman, whether chief cashier in a bank, he supervises, therefore is he a workman or a supervisor, and what they have held in the earlier cases, that was discussed. And ultimately, what is the test? The test is very important, dear friends. The test is not the designation. Anybody may have any designation, but the nature of work, what do they discharge, that is the test. The test to determine whether the employees in a bank, whether they were supervisors or the workmen, the test is what was the work that they were doing. They may have any designation, but let us see what the work that they discharged. So that is the test, dear friends. And ultimately, what did the Honorable Supreme Court has held? That I will tell you in the last. So this judgment was the combination of three honorable judges. Honorable Justice P.B. Gajendra Katkar, Honorable Justice A.K. Sarkar, and Honorable Justice K.N. Manchu. But this judgment was authored by Honorable Justice Gajendra Khatkar. This appeal by special leave arises from an industrial dispute between the appellants, the Lloyd Bank Limited, and the respondent, the Union of its workmen, in regard to 3 of its employees. It is not about all the employees, only 3 of its employees. The 3 employees are Pannalal Gupta, Poosa Ram Goyal, and Paras Ram Garg. These are the 3 people. The respondent claimed that the said 3 employees were entitled to a special allowance of rupees 50 per month. So the respondent claimed that the said 3 employees were entitled to a special allowance of rupees 50 per month. So this is what their claim was. Since it was in the year 1960s, so therefore 50 rupees also matters a lot. Ultimately, the Honorable Tribunal, after considering the work, what was the work that they have discharged? Let us then briefly summarize the findings of the fact recorded by the tribunal. The duties assigned to the 3 clerks in the audit department have been specifically set out in 3 respective documents filed on the record. We will take one as an illustration. The duties assigned to Mr. Garg are specified in 8 consecutive paragraphs. What was the work that was discharged? They consist of checking entries with vouchers in the 4 classes of books specified under paragraph 1, checking balances of the 3 ledgers specified in paragraph 2, checking entries, they were only checking entries in the 14 subsidiary books with the vouchers enumerated in paragraph 3, checking impersonal and cash balances weekly, checking contents of ordinary outgoing branch mail, doing the work of reconciliation of New Delhi branch accounts with the branches, and to prepare monthly branch reconciliation statements, also doing the work of checking monthly reconciliation statements received from the branches. So these were the work discharged by one such employees. Ultimately, what did the Honorable Tribunal held? On this evidence, I am reading paragraph 8, in which on this evidence the tribunal has found that the 3 clerks work as internal auditors and are overseeing and inspecting the accounts. They were overseeing and inspecting the accounts. According to the tribunal, they supervise the work of almost all the persons in the establishment with a view to ensure the correctness and authenticity of the accounts. The tribunal has also observed that the test of exercising directional and controlling authority is of doubtful validity, and so having regard to the nature of the duties and functions of the 3 clerks, they should be held to be supervisors under clause 9 of the award. So therefore they were held to be supervisors as per the tribunal. Order is concerned. The question now, the question which arises for our decision, that is before the Supreme Court, what is the question? The question which arises for our decision is, having regard to the duties and functions of the 3 clerks, as to which there is no dispute, is the conclusion of the tribunal about their status justified? Question mark. Whether the tribunal's order holding that these 3 employees or the supervisors, whether is it a justifiable order or not, that is the question that arises for consideration before the Honorable Supreme Court. I am skipping the submissions made by the councils. Let me take directly to the test. Dealing with such disputes, industrial courts generally consider the essence of the matter and did not attach undue importance to the designation of the employee or the name assigned to the class to which he belonged. So generally the designation is not important at all. So it was always a matter It was always a matter of determining what the primary duties of an employee were. Did he do clerical or manual work? If the answer was in the affirmative, he was a workman. That means clerical work means he is a workman. Where his duties of a supervisory nature, if the answer was in affirmative, he was not a workman. In considering the latter aspect of the problem, industrial adjudication generally took the view that the supervisor or officer should occupy a position of command or decision and should be authorized to act in certain matters within the limits of his authority without the sanction of the manager or other supervisors. Take the case now, they are considering the precedent cases. What was the similar judgments pronounced by the Honorable Supreme Court in earlier occasion? Taking the case of a checking inspector with which the industrial tribunal was concerned in AOR Nataraja-LAW versus Trichy Srirangam Transport Company Limited. This is a case law in which the checking inspector, whether he will fall under a workman or a supervisor, that was tested. This is AOR. This is not All India report. It is his initial AOR Nataraja-LAW versus Trichy Srirangam Transport Company. Yes, Trichy Srirangam Transport Company Limited. It is reported in 1955, Volume 1, Labor Law Journal, Labor LJ 608. Yes, no problem. 1955, Volume 1, Labor Law Journal, page number 608. In this case, the checking inspector had to check the conductors and drivers and to verify if they were doing their duties properly. Whether the conductor and driver, whether they are doing their duty properly or not, that has to be checked by the checking inspector. In that behalf, he had to send his daily check report. He has to inspect and he has to make a report also to the office. It was urged on behalf of the checking inspector that he was not in absolute control of any group of workers and that the report which he made had to be submitted to his supervisors for final orders. Though he makes a report, but the final order has to be pronounced by the manager. Even so, the supervisor, that manager has to pass an order, but still, even so, it was held that the general nature of the duties indicated that the checking inspector belonged to the cadre of supervisory staff. So he was held to be a supervisory staff. Though he makes a report, he goes and finds out whether the driver or the conductor, whether they perform their duty. Though he makes a report every day to the manager, but it is the manager who is supposed to take a final call based on the report submitted by the checking inspector. But still, the supervisory nature of the checking inspector was held to be a supervisor and not a workman. Even so, it was held that the general nature of the duties indicated that the checking inspector belonged to the cadre of the supervisory staff. Similarly, this judgment is over. Similarly, it is yet another judgment. Similarly, in the United Commercial Bank Limited versus LS Seth, 1954, Volume 2, Labor Law Journal, 457. This judgment you can find out from reading of this judgment. Sorry, sir? Yes, United Commercial Bank Limited versus LS Seth. It was held, what was held in this case, that is important. 1954 versus LS Seth, LS Seth, ACTH. 1954, Volume 2, Labor Law Journal, 457. It was held that, what was the test? It was held that the chief, page 457. It was held that the chief cashier of a banking company, who was responsible for all the acts of commission and omission of the employees, of the cash department, and under whose control and supervision the work of the cash department was done by the employees of the said department, was not a workman, since he belonged to the cadre of the supervisory staff. To the same effect is the decision of the Labour Appellate Tribunal in the case of the Burma Shell Oil Storage and Distributing Company Limited Madras. I repeat, Burma Shell Oil Storage and Distributing Company Limited Madras versus their employees, 1954, Volume 1, Labour Law Journal 21, page number 21. In this case, to be an officer, this is very important, dear friends, this is the test. To be an officer, it was held, an employee must occupy a position of command and direction and should be authorized to act without the sanction of the manager or other supervisors. The name of the designation of the employee is not a determining test. I repeat, the name or the designation of the employee is not a determining test. We have referred to these industrial decisions merely for the purpose of emphasizing the fact that in deciding the status of an employee, the designation of the employee is not decisive. What determines the status is a consideration of the nature and duties of the function assigned to the employee concerned, and that is why the point which arises for consideration in the present appeal lies within a narrow compass, having regard to the nature of the duties, and functions assigned to the three employees by the appellant. Would it be reasonably possible to hold that they are supervisors under clause 9 of paragraph 164 clause B of the award? In our opinion, the answer to this question must be in negative. So the Honorable Supreme Court has held that these employees will not fall under the supervisor, they will fall under the category of the workman. So the result is the appeal is allowed and the order passed by the tribunal is set aside. There will be no order as to cost, appeal allowed. So therefore, dear friends, let me sum up today what we have discussed. So we were discussing about Article 136, such a wide discretionary power vested with the Honorable Supreme Court. So when wide discretionary power vested with the Honorable Supreme Court, that power has to be exercised very cautiously, not generously. So very cautiously that is to be exercised, and we have given nearly 5 illustrations to discuss about when the Honorable Supreme Court will interfere. In the case of absence of speaking order, in the case of where the concurrent findings of the court, generally the Supreme Court will not interfere. But when there is a perversity, this is a beautiful term, perversity. Even on everyday hearing, when we argue before the Honorable Supreme Court, the Honorable Supreme Court asks the advocates, what is the perverse in this case? What is the perversity? What is the perversity? Perversity means it is an improper reception or rejection of vital evidence. It's whether if it is an important evidence that is not taken into consideration. If it is not an irrelevant evidence but that was taken into consideration and given an order. So it is improper reception or rejection of vital evidence. So that is perversity. So though there are concurrent findings of the fact, but still the Honorable Supreme Court will interfere when the order is perversity, when order suffers from perversity, or when there is a substantial grave injustice to the parties, or when there was a violation of the principles of natural justice. In these circumstances, the Honorable Supreme Court will interfere even with the concurrent findings passed by the courts below. This is second illustration. When the Supreme Court will interfere with the sentence or the fine imposed by the courts below. For example, last time we saw a particular case where he was indulged in black marketing. Rigorous imprisonment was given by the High Court. 6 months rigorous imprisonment, 15,000 fine. In which year? In the year 1950s, 15,000. So their Honorable Supreme Court has held, generally we will not interfere with the discretionary power exercised by the courts below while imposing a sentence or fine. But such a sentence or a fine has to be in proportionate with the offence that was committed. So therefore 15,000 was reduced to 1,000 rupees. In one such case, we have seen when an advocate was barred from practice for 5 years, it was reduced to 2 years. So therefore, dear friends, though the Honorable Supreme Court will not interfere with the discretion, but they have interfered when it is not proportional to the offence committed. Thereafter, yet another illustration that we saw today is that when the Honorable Supreme Court will interfere with the interlocutory orders. Generally, they will not interfere, but when the order suffers from absence of speaking order, obscure, then public interest demands, dictates the Honorable Supreme Court to interfere. We have seen several case laws on this. And then when the Honorable Supreme Court will interfere with the mixed question of facts, like as of now we have seen the dispute with respect to the who is the workman and who is the supervisor. So does not depend upon the test, does not depend upon the name or the name of the designation, but it depends upon the nature of the duty that they discharge. Thank you so much for your...
Here Supreme Court judgment is bad and not the legalized way, and they will not consider legal point. They will gone to this judgment on fact.
Yes, sir. Yes, sir. He must have preferred a review or curative petition. Thank you so much, dear friends. Wishing a very, very happy New Year in advance and Merry Christmas. Thank you so much. Thank you.